It's important to begin to know how a trial functions because the final assignment in this course will ask you to analyze a mock trial. We inherited our common law system from England, where the jury system was put into place to limit the power of the monarchy and to safeguard citizens against corrupt and biased judges and prosecutors. Today in the United States, juries are used extensively in criminal cases and also in many civil cases. Some types of cases, like divorces and probate matters, do not have juries. The basic function of a jury is to decide the facts in a case. The process of choosing a jury is called voir dire. Each potential juror is asked questions by both attorneys to see if there is any reason they should be disqualified. Generally, attorneys have two types of reasons to excuse jurors. One is called a challenge for cause, which means that there's something about the juror's background or answers to questions that the attorney feels would make the juror biased. The other is called the peremptory challenge. No specific reason has to be given in a peremptory challenge, but there's a limited number of them, so attorneys must use this type of challenge cautiously. Paralegals can be very helpful in the voir dire process. The goal of a successful voir dire is to have a conversation with the potential jurors. When an attorney has to question people and also write down notes, it is difficult. But having a paralegal write down the names of the jurors as they're called and making notes of their appearances can be very helpful. Are they dressed nicely? Do they look old? Do they have a grumpy appearance? What is your general impression of the juror? Did the juror fail to look at the attorney when they or the opposing counsel are talking to them? Are their arms crossed? Some may try to hide their preconceived notions of litigation with their answers, but their body language may give them away. Make note of any jurors that seem passive or outgoing. Are the jurors making eye contact, or are they looking elsewhere? Is their speech confident or hesitant? Do they seem anxious, relaxed, withdrawn, or bored silly? Evidence is achieved through witness testimony and exhibits. Closing arguments review and interpret evidence in light most favorable to the party. Jury instructions explain the law to the jury in understandable terms. Juries deliberate once instructed by the judge, and then a verdict is rendered by the jury. Judgment is entered by the court, and then post-trial motions are filed after the verdict is rendered.